Okay. So this is case number 2401653 GC Calvary SPV1 LLC versus Tarina, Tarena Ingram.
Good afternoon, Your Honor. Jeff Warber, P67124 on behalf of.
All right, Mr. Robert, good afternoon. Ma'am, what is your name?
Hello, Your Honor, Tarina Ingram.
All right.
Thank
And
you.
good afternoon to you.
Good afternoon, and thank you for hearing this case.
No problem. We have to do that. All right. And so today, from my understanding, I don't have a separate, submission with respect to this matter. It's my understanding that this is a Judge Arvant case and that there was a ruling on a motion to disqualify the judge, and she denied it for some reasons that she stated on the record. So I don't have a transcript of that. But you've asked me as Chief Judge to review the whole situation, pretty much de novo, as to whether or not Judge Arvant should be, in fact, recused from the case. So what is your basis that you're claiming that she should be recused from the case?
My basis is I compelled the motion, the date of the deposition, to compel to arbitration per the credit card agreement. I stated that I could compel arbitration at any time as long as there wasn't a default judgment or a trial started.
Okay.
So I did.
So this was a credit card debt.
Yes.
With the plaintiff, Calvary SPV now. And you're saying that whatever the agreement was on the underlying debt involved an arbitration agreement.
Yes.
And you're saying that that agreement specifically said that you could request it at any point in time.
Yes.
Okay. So what is the basis for the recusal of the judge?
She denied the motion and to a default judgment.
Buckle up, guys. Today we're going into a courtroom moment where a simple debt case turns into a full attempt to remove the judge. The defendant steps in confidently, insisting the court ignored her right to arbitration, but the chief judge immediately pushes back, asking for a real legal basis. It's the opening tension that sets the tone for everything that follows.
Now, you do know that there is a specific rule that outlines when a judge can be disqualified. So you're going to have to meet the standard under that rule. Now, typically, if a judge just takes an action on a case and you don't like it, that's an appealable issue to the higher court if you wanted to do that. But I'm not sure that that means that she should be removed. You have to meet the standard for disqualification. So what other than her ruling, what is it?
Well, it was unjust, and this lawyer attorney violated a lot of my rights. The debt was only $1,877. I never denied the debt, but this attorney never served me the original summons. Never served me.
Okay, but I can't, no, let me tell you what I can't do.
Okay.
What I can't do, because Judge Arvant is in charge of her rulings on her case. So I can't go back and change her ruling on the facts or the law. What I can do is decide if there was anything in the circumstances of what she did that would point to a reason to have her removed from the case.
She showed favoritism to the attorney from the beginning of the case.
How was that?
She made biased statements,
such as
when I told her that I mentioned that I never received the original summons. She said it didn't matter. You were put on notice with alternative order that I signed.
Was that alternative service?
Yeah. Yeah.
So what we call alternate service?
Or a second summons or alternate summons.
Oh.
Alternative order or.
So it sounds like you're saying that she's basically saying if you didn't personally have it, that alternate service would satisfy it. So that's a court ruling. How does that show bias?
It's just statements that she made. She didn't, everything that I said, she didn't hold him accountable for anything. She didn't ask him anything. Well, what steps did you take to serve her? she just, showed him favor. He told her, he said that, Your Honor, you know me. I've been in your court before. He made oppressive statements and during the mediation on the Zoom video, the judge is going to enter default judgment against you. He said it several times, like threatening and abusive and oppressive statements.
Okay, that's what he did though.
Yes.
So here's the thing. The rule really sets out the kinds of things that the judge has to do. This is a pretty high standard to get somebody removed. And I understand you might not like the way she ruled on something. And it could be the case that you don't understand how she applied the law on some things. Because I will say this, and I'm not commenting on the validity of her ruling, but I can tell you that alternate service is usually given by court order when someone has had trouble personally serving. And so that is considered good service under the court rules.
Yes.
So I don't know if there was something wrong with her ruling there, but I can just tell you that that pretty much is normal. And if you're following the rules, if the judge is doing that and you don't like it, the real remedy is to appeal it and see, not to me, because I'm not a judge, but appeal it to the next higher court if you think that there's something legally wrong with what she did.
Right.
Because, you know, for this, you have to have real specific facts of how the judge would be biased or prejudiced. What is it she actually did other than just ruling on the motions or ruling on your requests or saying things like, well, it doesn't matter because you got alternate service. That's not a bias. That's really stating what the law says.
Right.
So you have to have a really good reason to show bias.
But it was my third motion, the third one. She already listened to the disqualified one and she denied that.
Right, and that's what you're appealing to me, is her denial of that.
I'm appealing it.
Here the judge presses harder, reminding the defendant that disagreeing with a ruling isn't grounds for recusal. As the defendant insists the decision was unjust, the judge calmly redirects her to the actual rules, making it clear that emotional frustration doesn't meet the legal standard. This moment shows the judge firmly recentering the case on facts instead of feelings.
You have to go to circuit court to appeal her ruling on the set-aside default. The only thing I can do is say whether she should have removed herself or not. That's the only thing I can do, because I'm not sitting as an appellate judge. The appellate judges are at the Oakland County Circuit Court. So you could have done one of two things. Probably you could have asked her to reconsider her ruling. And if there's nothing new you're presenting, then she may not reconsider it. The ruling might be the same. Or you could, within the time frame that's allowed under the court rules, you could file an appeal up to the circuit court. And they would have to look at it and see if she did something wrong I guess, ruling on that
She
motion.
overlooked my complaints of the attorney violating my rights, my civil rights, and as a consumer. She overlooked that. She didn't look into that at all. She just overlooked it and just reprimanded me. She overlooked my rights being violated.
Okay, well, what rights were violated that caused her, that is showing some kind of bias?
Improper service. She didn't look into anything. The
I
documents.
thought we just went over the service part.
Well,
alternate service.
and then
It might be good.
the oppressive statements that he made during the mediation. To me, that's a violation of the Federal Credit Consumers Act, that a debt collector or whoever's not supposed to make oppressive, abusive statements to collect the debt. He said it several times.
Well, okay, so I don't know what you asked her to do because I have no transcript. No one has given me a transcript of what actually occurred. And I'm really hearing this de novo, which means from the beginning, as if you never did it over there with Judge Arvin. So I'm trying to understand, what is it? Now, let's just say he did what you said, and he said some oppressive statements to you. What about that causes the judge to have to remove herself from the case because he made these statements to you in a mediation? Which, and let me just say this, normally, whatever's done at mediation, we don't know anyway. We don't really get involved with these.
Okay.
That's called a settlement process.
Okay.
So we usually don't even know what happened at the mediation, of what, if there was an offer or not, and where they were, or how far the parties were apart. you know, what you offered them, what they said they would accept or wouldn't accept. We don't really know that because that's a settlement negotiation tool. But if you're saying he said something that you thought was offensive, what was it that you asked the judge to do? What was she supposed to do? And how does that show she was biased against you or prejudiced against you? Because it's a very high standard. What you're asking me to do is remove her from that case and have it reassigned to some other judge.
Okay.
And that's the only thing I can do. I can't look at whether she was correct in her ruling on something because that's an appellate.
Okay.
That's an appellate issue. But I can say if something she did seem like it was rises to that level of bias or prejudice against you, then I would say that motion, if you're asking for her to recuse herself, then that should be granted. And then I would have it reassigned to someone else. Either myself, it's a blind draw, myself or the other judge could possibly get it. But you would have to meet that standard just on that. So unless she said or did something that shows bias, we can't worry about the actual ruling itself.
Okay.
If you understand the difference.
Yes, I do. Yes. She made a few statements. I mean, this happened a few months back. I can't recall everything, but I did write some things down. Like I said, she was showing bias favor towards him when he told her, "You know me, Judge." And she made a comment about, well, some people just don't like to be served. I think that was biased. That wasn't just for her to say that because he never served me. So she was automatically.
When you say serve, you mean personally?
The summons, yes.
Yeah.
And she said.
This section dives into the heart of the conflict. The defendant continues arguing favoritism, but the judge breaks down how alternate service works and why her complaint doesn't equal bias. Watching this, you can feel the gap between what the defendant believes happened and what the court is legally allowed to act on. The tension sharpens as clarity meets resistance.
Well, how's that bias though? That's just a fact that is actually accurate. There are people that what we call evade service.
Right.
And if people evade service, then they can come back and ask the court for an order of alternate service, meaning that you don't have to hand it directly to them.
Right.
But you do.
On the door or something.
Yeah, you have to tack it. You have to do it certified mail and first class mail. Do things that would be reasonably calculated to get a person notice of a lawsuit.
And he didn't do any of that. He didn't do any of that. And that's what I'm saying. She didn't listen to me, period. She didn't look into anything. Okay. He didn't do any of that.
So you believe she was expressing a bias because she didn't look into
the case, the details,
and the details of the service.
Yes, and what I'm claiming, I showed up, what I'm saying. She didn't look at anything. So he didn't do any of that. He didn't do anything. He just was deceptive and did all these tactics that he's not supposed to do, and he got away with it. And she empowers that. It's an article that I submitted to her about these debt collectors buying debts less than $2,000 for pennies on the dollar, and they're targeting minority and predominantly black communities. There's a justice report.
Okay, well, what would you like her to have done with the article and the fact that
I would have liked to look targeting black and listen, give me a chance and be just and fair and not look at me and treat me like I'm a criminal because I experienced some financial hardship. I paid my bills. I had 11 credit cards that went bad. I paid them all. I'm down to 4. She didn't give me an opportunity to express and state my claims and show proof. She just reprimanded me and she directly favored him and gave him the green light to do what he's doing. He never served me. He went to for a gun.
Didn't we just say though that she ruled on the service and said that there was alternate service, so she didn't have to serve you, and they didn't have to serve you personally?
But he didn't serve me at all. He didn't serve me.
Well, you don't think you got it served any other way? It wasn't tagged. It wasn't sent by mail. It was nothing. No, there was no certificate. There was nothing.
No.
And wait a minute. Hold on, Ms. Warner. I'm gonna get right to you in a minute. So normally the judges would look in the file,
right,
and it will show how it was served.
Right.
You're saying this case showed nothing.
No,
Okay.
And there was a few documents that some server documented that they came out to my home.
Well, that's what we
Three
looked at.
times, 2 times I was at work. They were work hours. I worked 9 to 5. Two of those times was work hours. And then the third time, I don't know, I think it was on a Sunday or something, and I'm home. I'm out walking my dog, I'm sitting on the front porch. But the 2 times it was documented that, because I looked at the register, it's called register or something. I came up here. It's called register and accident or something.
Yes.
Yes. And 2 of the documents that the young lady documented saying, the windows was up, the lights was on. This was in May. And I was at work both of those times. I worked 9 to 5. I was working in Redford. I work in outpatient. I'm a registered nurse. And
So you believe that she should have held a hearing?
Yes.
As to whether or not the service document was accurate?
Yes.
Okay, well, if she didn't, how does that show bias? That means maybe she was wrong in what she did procedurally, and that's an appellate issue. How does it show bias? I have to get to actual biases. Almost, not totally. Very difficult, if not impossible to show. You have to have a lot more than what you're saying, which is, her rulings on the particular case.
She favored him.
Okay.
And the article stated that these debt collectors are buying debts and targeting Black communities and minorities versus middle class communities. They're targeting the Black communities and minorities.
Okay, and you know what? Maybe that's true. But how does that mean I should recuse the judge because she didn't look at the article?
But isn't that her job?
To look at your article? No,
to look at the case.
Yeah, she has to look at the case for sure. But the question is, if you wanted her to look at an article about how the debt collectors are targeted.
She said I asked her, did she look at it? She did. I seen it, and she just, and that's fine. She didn't elaborate.
Okay.
She didn't look at the case and ask more, information from them. They never served me, Your Honor.
Okay.
They never served me.
I understand what you're saying, but that's the issue I can't deal with. I can't go back and change her ruling on the issue. All I can do is look and see if whatever she did was bias or prejudice.
It was. Yeah, she was.
Well, that's what you say.
Right. And she made a comment to the Zoom. There was a Zoom hearing going on before my case.
Because
she referenced me to that Zoom hearing, whoever case that was. She made a reference to me, comparing me to that. I didn't elaborate because she was already frustrated with me.
Now the judge reviews the service attempts line by line. The defendant insists she was at work and never served, while the judge explains that the court relies on documented attempts, not personal assumptions. This sequence highlights the courtroom struggle between lived experience and written record, and you can sense the rising frustration on both sides as details collide.
And on that meeting, it was a Black couple and it was a Caucasian attorney. That's the only thing that I've seen maybe that was in common, but she referenced and that's not right. She's not, I don't think that's lawful for her to even do that. She made a reference to the Zoom.
Remember, I'm not looking at lawfulness per se. I'm looking as to whatever. See, you haven't given me any specific. I'm just hearing all this for the first time.
Right.
There's no brief, there's no motion. So I'm just hearing, you're telling me she said this, she did that, without me actually seeing what it was.
Well, can you look into it?
Claim that she said. It's everything to me sounds like she's just ruling on a case, and I'm gonna let him respond back to what you're saying now, and we'll go from there. Go ahead. What do you want to say?
This matter is simply about following the court.
Well, that's what I'm trying to explain to her.
Exactly.
Before you even start, I'm not trying to side with him. I was trying to tell you earlier that you have to follow what the rules say.
Yes.
And if she did or didn't follow those court rules properly, that's in a case for an appeal. And it wouldn't necessarily be that she's biased against you and for him. That's just a ruling. And unfortunately, in this job, we got to rule against somebody one way or the other.
I understand.
But if it's just a matter of court rules I'm hearing, that's what I was telling you earlier, I'm hearing more of it. Sounds like she was just applying the rule on alternate service. Now, if you think you should have had a hearing on it, because she gets a chance to rely on what the process server said. But if you bring proof showing that what the process server said couldn't possibly be accurate, then I typically might hold a hearing on it and see if we can find out what did happen. But I don't know what you brought to her. And if she said, well, no, based upon what I've got here, it sounds like the service was okay, then that's a ruling you would have to appeal, because I can't touch that.
Right.
I cannot go behind any other judge and change their ruling on something. Like I said before, it's simply a matter of if they did do something and it shows bias, then I can take the case away from the judge and assign it to somebody else. So that's what he's saying, is he believes it's mostly, as I was trying to tell you before he started,
Yes.
mostly kind of like a court rules issue. Did she just rule on the court rule, whether you like it or you think she was wrong or right? Does that show bias?
I think she just ruled because the three document dates on the register of action, the 2 dates I was at work.
Okay.
That was for alternate service, Judge.
Yeah, I'm looking at.
So here's
She
what
had a
happened.
motion.
She was served by alternate service and she found an answer.
I
And
did.
that's what Judge Arvani told her.
Okay,
She filed an
let's look
answer.
at that. Let's look at that. So I'm looking at it right now. There's an order for alternate service for first-class mail tacking and certified mail return receipt. That's the things that we usually allow when someone is not able to serve personally. And that was signed on June 25th.
I responded July 17th.
Correct. She found an
And
answer.
I-
Which means she
How
was
did you,
served.
Let me talk.
let's get to this. How would you know to file an answer if you weren't served?
This is with the alternative. I'm talking about the first order. I never received the first summons, the original summons. I never received.
That's okay.
Those are the 3
Let me
dates.
tell you why it's okay.
Okay,
Because again, if they try to give it to you,
which they did not.
well, I don't know if they did or not.
If you look at the days, those, out of the 3 times that was documented, 2 of the days was work out.
Okay, well, once they put that in and they say what they say, that they went to your home on a day, you say you're at work, we don't know specifically where you are. It's an ex parte motion. That means that we're only hearing from the one side. They tell us that they can't find you for whatever reason. Then we order the alternate service. The real issue is, did you get it by alternate service? And you must have, because you filed your answer. So there's really nothing wrong in that process.
It's failure.
Here the defendant argues that the service process was deceptive and that broader issues, including targeted debt collection, were ignored. The judge listens but redirects her once again to the limited question at hand: bias, not the entire case history. This moment shows how easily a litigant can mix systemic concerns with procedural rules, and how carefully the judge separates the two.
They didn't serve you by hand, but they served it properly by law. Because as Mr. Werber said, the court rule allows them to do it alternatively.
Right.
So they can do it the way they did it, and it's good.
And that's fine. Yeah, I understand that. But what I'm saying is, and I know there's nothing that can be done about it because you have to have proof this and that. What I'm saying is they were deceitful with the first summons. But that's neither here nor there because I can't.
But how does that mean the judge did something wrong?
Because she didn't look into it. She didn't look at the register. She didn't look to see, did you try to serve her? She didn't look. Because out of the 3 times,
I see it right here. And they just tell you the 3 times. We don't have to go into a hearing on that because it's ex parte. That means that you don't have a say in that motion because you're not a party to the case yet. We're only talking to the people that are a party in the case. They're telling us we're having difficulty finding her.
which is a lie.
Okay, that might have been. Maybe they were wrong.
Yeah, they were lying.
Maybe. But I don't know. But that's what we get.
Right.
And so we don't go investigate to that degree. We take them at their word that they have not been able to serve you personally. And as long as they serve you alternatively, and we authorize that, that's good service, whether they didn't serve you the way you want it to be the first time or not, whether it was a mistake or they actually lied about it. As long as they got you served is what the courts are really, really concerned about, because you have to have an opportunity to come forward and be heard.
Right.
And you did have that opportunity
On the second one, yeah.
on the second one. So she wasn't wrong in telling you, well, we're not looking at that
Right.
because we got good service on you and you did file your response.
I did, and then I filed my response on the 17th, and then they came out again on the 23rd and tacked it to my garage door. No envelope or anything. The packet was really thick. When I pulled up at home, the packet was on the ground outside my garage.
Yeah.
You know,
But that's still service.
but it's not proper though.
Ma'am, I'm here to tell you, if you had had this case before me, you wouldn't like me either, because I probably would have ruled the same way.
But I understand the way that you explained it.
Yeah, but I'm trying to do my best to
Yeah.
make sure, and I like my litigants to understand what's going on, to know that they're being heard, and to know that even if your argument's considered, if I got a rule against you, at least you understand why.
Right, yes.
And that's what I think is important. So hold on, let's hear from Mr. Werber some more. Go ahead, Mr. Werber.
I appreciate your patience here, and I think Judge Arvon did exactly the same thing you did when explaining to the defendant why she was served.
So maybe it just comes off better from me.
Whatever it is.
She recommended it.
You both said exactly the same thing. And I was there and I listened, and Judge Arvon tried to tell her exactly what you just said.
No, she did not.
Excuse me.
She was recommending me.
Hold on, he didn't interrupt you.
I'm
You got
sorry.
to speak.
Yeah.
It was exactly the same. Again, the defendant keeps on referring to a default judgment. There was never a default judgment entered in this case.
Yeah.
There was a motion for summary disposition filed.
Right.
Oral argument was heard, and the judge granted the motion for summary disposition. Nothing unusual was taken, and I want to make sure for the record, we remember that just today, the defendant admitted that she had the credit card
did.
and
I didn't deny it.
admitted that she owed the debt.
She did.
So
Yeah.
what are we doing here today?
Right.
Excuse me, I am not gonna allow
Okay,
this.
stop.
You don't have
First of all,
to
nobody allows anything but me.
yell.
So address it to me, Mr.
Okay,
Werber.
I
I
would-
know both sides are
I
frustrated.
would appreciate you telling her not to talk when I'm talking. Yeah.
So ma'am, that's what we don't do, is when he talks, I talk. Because otherwise the court can't hear what either side is saying, and you want me to be able to hear it. And yet nobody wants to fine anybody for contempt because you're disturbing the process, because you're talking over each other. I don't like to do that. I very rarely do that. So I'm just telling you, just wait, just calm down. It's okay. Let Mr. Werber, you calm down too. Wait, you be yelling in my courtroom and we don't.
This is where tension peaks. The attorney lays out the case timeline step by step, and the judge must step in when voices clash. The defendant interrupts, emotions spike, and the judge restores order with authority. It's a raw look at courtroom pressure, where legal structure meets personal frustration, and the judge must hold the line to keep the hearing on track.
The defendant filed a motion to dismiss.
Right.
It was heard
Mhm.
and denied.
Got it.
She filed a motion to compel arbitration. It was heard and denied.
Mhm.
Plaintiff filed a motion for summary disposition. Oral argument took place. It was granted and the judgment was entered. This was all back prior to November.
Okay.
The court rule is very clear that the MCR 2.003 sets forth the grounds and procedures for disqualification of a judge.
Right.
Two things have to be filed. Very important. Number one, the motion has to be filed within 14 days of the ruling. Number two, an affidavit, sworn testimony that's notarized must be attached to the motion. Neither of these were done. I was served with this motion on Monday, February 10th.
What did you receive?
I received a motion to, biased and favoring plaintiff denied. Motion to compel arbitration on February 10th is when I received it. So again, defendant has not followed the court rules again, which has to be done. And I will just simply really quickly discuss the motion to compel arbitration. You must, in your answer as an affirmative defense,
Yeah.
plead arbitration.
I'm not
And
even
defendant-
getting into Judge Arvin's ruling on that. I just want to know how she was, well, however she ruled, wrong or right.
And
How is she showing bias is what I'm
exactly,
talking about.
there's been,
And that is true, that you do have to plead, even though your contract may say, we don't mind when you ask for arbitration. The law says you have to plead it in your first answer. because it's what we call an affirmative defense. And it's something that could defeat their whole case. And so that's what an affirmative defense is. And those kind of defenses, you have to state it in your answer. So I don't know what the judge did because I don't have a transcript. But if she said you didn't plead that in your first answer, then it's not timely. Then she has to deny that motion. But I'm not here to say she was right or wrong on denying the motion. I'm here to see whether in denying the motion, was she showing some bias? And it sounds to me that she was just trying to follow the court rule that says you have to plead it. And the unfortunate part about it in these type of situations when you don't have a lawyer is you don't know what those rules say. You know, and so you're kind of at a little bit of a disadvantage.
Yes.
That doesn't mean that she was doing it wrong in an effort to show a bias against you. So he's right from that standpoint that if she didn't do that, she was probably right. And I don't know how that shows bias if she's just following what we know that the Michigan court rules say you have to do.
I understand.
And that's my whole point, and that's what I started with. It's all about following the rules. It's all this. And I apologize for being frustrated. This is at least the 5th hearing I've been to on this case.
But you know, sometimes when things get to me, sometimes I have a way of explaining things and making people feel more comfortable with what has happened so that maybe you're not going to be back here on anything else.
I absolutely hope so, and I will sit down and let you.
Okay, so ma'am, I'm hoping that you're understanding because
I do.
he's right that the court rule and order and my role, as I told you, is very limited.
Yes.
So the court rule just does require, as he said, those certain things. You have to file a motion with a certain time frame. You should file an affidavit. And you didn't do any of those things. But even if you didn't, you still have to be able to show me bias and prejudice. And I'm going to show you a little bit what the law says, is that a trial judge is presumed to be unbiased. So you're starting with that standard, that they're presumed not to be biased.
Okay.
And then you have to then break through that rule to show me how they are biased. And so there's a case that supports that, and it's People versus Houston.
Okay.
179 Mishap 753-756. So that's the case from the Michigan Court of Appeals. And the party that wants to have the judge disqualified, which would be you, would have the burden of proving that your motion is justified and that the judge is either biased or prejudiced.
Okay.
And then that's under that rule 2.003. And you can feel comfortable in writing that down. You can look it up online. You can just put Michigan Court Rule 2.003. It'll pull it up and it'll show you everything that the rule says.
In the final stretch, the judge delivers the legal reality with precision. She cites the presumption that judges are unbiased, the high threshold for proving actual bias, and explains why none of the defendant's claims meet that standard. It's a calm but decisive conclusion that closes the door on the recusal request. If you've made it this far, don't forget to like the video and subscribe to the channel, and we'll see you in the next video.
Now give you the stop. Okay. And so you must overcome what we call the heavy presumption that the judge is not biased. And so the rules say if the judge is biased or prejudiced, then of course he or she should be disqualified. If the judge, based upon objective and reasonable perceptions, that means a reasonable person is looking at the whole thing and they come to the conclusion that it could be a serious risk of actual bias, which impacts your due process, or the judge has failed to adhere to the standard that we call the appearance of impropriety. That means if the judge is in a situation and it looks unfair, then they should probably be removed. So you have to show the actual bias or that there's a serious risk of actual bias, which will affect your constitutional rights. Or if the judge is showing the appearance of impropriety based upon something that they've said or done. That's very high standard.
Yes, it is. It is.
And then, let's see, I'm trying to see if I got another case here for you. Yeah, you have to show actual bias is what the cases say.
Okay.
And that's very difficult to show.
It is.
Um,
It's difficult, period, as a consumer, when you're standing against someone that has a law degree. Well, it's difficult.
Right, because you know what, if you understood it a little bit better,
Yeah, I
you
think-
might have said, okay, maybe I get why she did what she did. But nothing that it sounds like that you're even telling me meets any of these.
But I did do some research, and I am starting to become educated with these laws of these debt collectors, what they can do and what they can't do.
Well, then, you know what? You could seek counsel and see if you have some claim. I guess is that.
Yes, I will, because
But right now, I don't know that you do.
even on my credit report, they filed inaccurate information.
So we just gave you a copy of this, the court rule we've been citing, 2.003. And that's what the rule says as far as, you know, what you have to show. And then the cases that I just cited to you tell us what that rule really means.
Okay.
And so I don't think you've shown me the actual bias standard that would be required for me to remove the judge from your case. Nor do I think that you have shown me that it's a circumstance where it's the appearance of any impropriety that the judge has done. It sounds like she was just ruling, whether right or wrong, pursuant to the court rules. Also, I'm not sure that you have showed me that there was any serious risk based upon something about the circumstances that there could be bias. So there's no actual bias, there's no serious risk of bias, and it does not appear that there is any appearance of impropriety here. So I'm going to have to deny your motion to remove her from the case. So I'm not really commenting on whether she was right or wrong, but it just seems like she was doing what she should have done, which is follow the court rules to the best of her ability. That if you think that she did something wrong there, the process would be to appeal it to the circuit court.
Okay.
Okay?
It does.
The other thing I'll say, just for the record, because I don't, like we said, I don't want to stick steer in this matter. At least based on,
Okay, stop. Don't comment. Just let me say what you got to say.
based on the court rules, the time period.
Okay, well, you can look into this.
Yes, I will.
If you want. Telling you based upon what he knows the rule to be. If you wanted to appeal, you probably have your time. Okay? Did you have any other questions?
No, Your Honor. Thank you so
Very
much.
good. I will prepare an order, denying the motion, and it'll say for the reasons here stated on the record as well.